Welcome you all to the class, the 1951 Convention, a Decolonial Critique by Professor Sabyasachi Basu Chaudhury. Sabyasachi Basu Chaudhury is Professor of Political Science at the Rabindra Bharati University, Kolkata, and the Honorary Director of the Calcutta Research Group. He has been a key member of CRG for the past many years. His areas of research interest include South Asian studies, in particular politics of globalization, democracy, development, displacement, human rights, and justice in South Asia. He is a regular contributor to academic journals, periodicals, dailies, news channels, and portals. To name a few among his publications, such as Dispossession, Unfreedom, Precarity, Negotiating Citizenship Laws in Post-Colonial South Asia, published in the South Atlantic Quarterly in January 2021, The Rohingya in South Asia, People Without a State in 2018, Sustainability of Rights After Globalization in 2011, Indian Autonomies, Keywords and Key Texts in 2005, Internal Displacement in South Asia, the Relevance of UN's Guiding Principles in 2005. We would like to thank Professor Basu Chaudhury for today's class, and we also thank IWM Vienna and Rosa Luxemburg Stiftung for their constant support. I am Chaudhury Das. I am researcher with the Calcutta Research Group, and so we request you to please begin today's class. Thank you.
Thank you, Shatabdi, for an elaborate introduction, and good evening to all of you. And we'll be having a discussion on the 1951 Convention, as my colleague Shatabdi has just said. And as she has already told you, it will be on the 1951 Convention, a decolonial critique. Now, it will be an interactive session. All of us are teaching somewhere in colleges and universities, and therefore it is more of an interaction. And this is the 70th year of the 1951 Convention, and therefore it is probably the time that we take a stock of this convention, which defined the refugee for the first time in the post-war era, and which has remained the cornerstone of the international refugee law, this convention, for the last 70 years or so. So when we are going to discuss this 1951 Convention on Refugees this evening, we'll be discussing this from the perspectives of critical jurisprudence and decoloniality. And in this endeavor, we shall try to move beyond the resolution of a crisis, as we shall see that this has been the reigning orthodoxy of international refugee law, that quite often overlooks, the precarity or unfreedom of the refugees and migrants, considering the refugee situation, any refugee situation for that matter, as a crisis. And as we know that the 1951 Convention was born out of a crisis once again, produced crisis. I'm always using it within inverted commas, crisis produced by the Second World War. And even if we look at the very recent, the New York Declaration of 2016, containing two different global compacts, one on refugees and the other on migrants, these have also been, framed in the context of another crisis, we may say, of the European and Mediterranean region in 2015. So we are going to look at it, and we are going to raise some questions. Definitely, you will have your own questions, and I'm not, claiming that I will be able to answer all your questions. I am also raising a few questions. Let's see how it goes about. So first of all, we probably need to remember that mostly the social scientists, lawyers, human rights activists, civil rights activists, They study and analyze the 1951 convention. Although the lawyers, social scientists, and activists, they are not always on the same page. And with due apologies uh, to all of them, I am constrained to state that sometimes it appears from the way the legal practitioners view the national and international laws as if law does not have anything to do with society, its history, economy, and political developments. To most of them, law is given. It's something given. Similarly, if we look at the social scientists, they quite often prefer to treat the refugees and asylum seekers from the perspective of national security and geopolitical perspectives, ignoring the human sufferings. All the more with the growing securitization of refugee and migration issues following 9/11. But if we look at jurisprudence, jurisprudence is also the conscience of law. That is an exploration of law's justice. And jurisprudence usually it brings together what is and what ought to be, the positive and the normative. That is why we also talk about positive law and normative law. But jurisprudence over the years has become more restrictive and academically peripheral in recent times, both nationally and internationally. And therefore, the collection of national and international laws uh, appears simply as a guidebook, say to we can say technocratic legalism and a legitimation of the existing legal framework. Critical jurisprudence, about which I'm going to say a few words, on the other hand, it returns to the classical tradition of general philosophy of law and adopts a much wider concept of legality with transformative and an emancipatory agenda. Similarly, when we talk about critical theory in social sciences, it can hardly ignore the habitus. I'm using here the term of Pierre Bourdieu, the habitus of the refugees, asylum seekers, and migrants to underscore the security of states. So law does not simply exist as we see, but it is made by the political actors, decision makers, or the powers that be. Therefore, those involved in the process of lawmaking have the power also to set some standards. And history shows that the colonial and imperial states generally dominated the debates on international legal framework, while the colonized ones were excluded and also thus, we can say, silenced. Despite the broad support for the universal refugee definition, as we shall see in the 1951 Refugee Convention, several powerful delegations demanded its limitation to Europe, and therewith strategically subordinated and ignored, as they say, the other refugees and the other regions and the other histories in pursuit of the geopolitical interests of the European powers. They thus also made the colonial others in this manner irrelevant in the creation of international, what we call international refugee law. Therefore, the international community represented in the newly established United Nations drafted the Refugee Convention soon after the Second World War, and the states adopted it at the Conference of Plenipotentiaries in 1951. And the decolonized states and the refugees in those decolonized states, which were decolonizing just immediately after the Second World War, had no effect on the convention's creation, framing. Instead, the events in Europe appeared to have been more decisive. While Europe was undoubtedly influential, the main focus on that continent reflects a bias towards Western history and not global history, and certainly not colonial history. In this scenario, what might this mean for us when we are talking about the 1951 convention? As scholars, to attempt to decolonize, international refugee law when we are celebrating 70 years of this convention this year. Does identifying colonial logics within structures of border control or humanitarian protection leave no other choice than to swiftly and decisively abandon those structures in search of something new? Or can an ongoing process of critically reconsidering the theory and of practice of refugee law inspire and guide other forms of engagement? I was talking about at the beginning about a transformative and emancipatory agenda. So in this scenario, we shall have a quick discussion on these issues in the next, say, 50-55 minutes or so, borrowing instances primarily from South Asia, because I have been working on South Asia, so I shall be concentrating more on South Asia and a little bit on Southeast Asia. The 1951 Convention on Refugees has still now, as I said, been considered as the pivot of the international refugee law in the post-war era. But as the number of displaced persons seeking refuge has recently multiplied exponentially, accompanied with mixed flows of refugees, migrants, and asylum seekers, the states are now increasingly resorting, and the states, meaning the states of both the global north and the global south, they are increasingly resorting to measures to circumvent their obligations under the 1951 Convention. And these range from the bilateral agreements condemning refugees to their vessels at sea, to the excision, that is, removal or deletion of certain territories from the so-called national jurisdiction. There have also been attempts to externalize the incoming refugees and asylum seekers by the countries in the global north to sidetrack the principle of non-refoulement. We have instances from Europe, from Australia, from the United States. I'm not going to, elaborate on that at this point. Now, while the socio-economic developments emerging from neoliberal economy, which is also another development, and the revolutionary changes in information and communication system have led to deterritorialization of vast domains of the economy and also of the media, enabling them to escape from, we can say, the state control territorial presence, whether on terra firma or on vessels at sea, which are functional surrogates for territorial sovereignty, still continues to be the basis for the entitlement to human and citizens' rights. So in other words, we can say that we are facing a simultaneous process of deterritorialization and re-territorialization at once, both of which threaten, in my understanding, the 1951 Convention. Now, first, let us go back very briefly to the 1951 Convention, its genesis, its origin. The 1951 Convention, we can say, we know, some of us or many of us or most of us, that it was not the beginning of the process of lawmaking concerning refugees at the international level. The international legal instruments of the League of Nations period or era primarily comprised at least 5 arrangements made between 1922 and 1935 concerning Russian, Armenian, and other refugees, the agreement of 1928-29 between Belgium and France, the Convention relating to the international status of refugees 1933, concluded by Belgium, Bulgaria, Egypt, France, and Norway, and subsequently adhered to by a number of other European states, the Convention of 1938 concerning the status of refugees, mainly originating from Germany and its related protocol to 1938 Convention, and the Avian Resolution of 1938. In Avian Resolution, in this context, we can remember that the delegates from 32 countries and representatives from refugee aid organizations in those days attended the Evian conference in Evian, which is in France, we all know, between July 6 and July 15, 1938, to discuss the options for settling the Jewish refugees fleeing Nazi Germany, elsewhere in resettling them elsewhere in Europe, the Americas, Asia, and also to some extent in Australia. Moreover, We also should remember that on 5th of July 1922, on Nansen's initiative, Nansen was Fridtjof Nansen, the Norwegian polymath and also Nobel laureate. An international agreement was signed in Geneva, introducing the identity cards for displaced persons, known also as the Nansen Passport, a provisional, internationally recognized travel document valid during 1922 and 1938. All of these legal instruments were valid till the end of the Second World War. However, all of these were in relation to only, as we noticed, to the specific categories of refugees defined by their origin and their nationalities. They were no longer, therefore, relevant for the refugees during or after the Second World War. In fact, we can say that immediately after the Second World War, there was a vacuum juris regarding the travel documents for the refugees or the displaced persons. Vacuum juris meaning that there was a legal void, legal vacuum. At the initiative of the Intergovernmental Committee on Refugees, an international conference, therefore, was held in London. And the delegates in the conference signed an agreement on 15th of October 1946 concerning the issue of a travel document to the refugees. The London travel document was widely adhered to in Europe for a long time. Subsequently, in its resolution 319, paragraph 11b of 11th and 16th August 1950, the Economic and Social Council, ECOSOC, decided to follow the recommendation of a study leading to a convention approved by the UN General Assembly. Eventually, we see that with its resolution 429, Roman paragraph 5 of 14 December 1950, the UN General Assembly decided to convene a conference, as I said earlier, of plenipotentiaries in Geneva to complete the drafting of the convention relating to the status of refugees. And this conference, as I said, was held in Geneva from 2nd to 25th July. So that means more than 3 weeks in 1951. 28 plenipotentiaries, including 2 observers, represented 17 states from Europe. Please note the number, 17 states from Europe, 6 from the Americas, only 4 from Asia, and only one from Africa, and only 1 from Oceania. The decolonization process had just begun, we know, and the consequent 1951 convention relating to the status of refugees was open for signature on 28 July 1951 and remained open for signature till 31st December 1952, almost for, you can say, 17 months. And this convention defined the legal status of the refugee, quote unquote, also took into account the interests of the contracting parties, contracting states, which is very important. And also, we can say that it also outlined the nature of collaboration, cooperation between the contracting states and the UNHCR, the United Nations High Commission for Refugees, and also settled the relations between the 1951 convention and the previous treaties, which were, existing prior to the Second World War. Now, if we come straight now to the 1951 convention, the convention, its Article 1, paragraph 2, defines a refugee as a person who, I quote, owing to well-founded fear of being persecuted, I repeat, for reasons of race, religion, nationality, membership of a particular social group, or political opinion, is outside the country of his nationality and is unable, or owing to such fear, is unwilling to avail himself of the protection of that country, or who, not having a nationality and being outside the country of his former habitual residence, as a result of such events is unable or owing to such fear is unwilling to return to it. So this is briefly the definition given by the 1951 convention at that point of time. So having said that, we can say that we can remember that the subsequent regional instruments that have been developed since the 1951 Refugee Convention have often expanded the categories of persons who would benefit from protection. For instance, the 1967 protocol broadened the applicability of the 1951 convention. We cannot nowadays discuss the 1951 convention without discussing the 1967 protocol. This 1967 protocol removed the spatial and temporal restrictions that were part of the 1951 convention so that the convention could be applied universally. So this is a significant development. You can see that the convention, which originated in the context of the Second World War and its aftermath, the more refugees in Europe and that kind of crisis. So it was now made universal. It was now made universally applicable. And Article 1 of the 1967 protocol says that the countries that ratify it also agree to abide by the Refugee Convention, that means 51 Convention as well, even if they were not a party to it. So if we ratify the 1967 protocol, by default, we also accept the 1951 Convention. So these limits, as I said, initially had restricted the convention to persons who became refugees due to the events occurring in Europe before 1st January 1951. Before 1st January 1951. Now suddenly it became universal. And after 1951, new refugee situations arose in different parts of the world. And these new refugees did not fall within the scope of the 1951 Refugee Convention. And therefore, this protection gap led the governments to frame the 1967 protocol as they considered it desirable that equal status should be enjoyed by all the refugees covered by the definition in the 1951 convention, irrespective of that earlier deadline of 1st January 1951. In reality, there are now multiple definitions. If we see it today, there are multiple definitions of the term refugee. There is the definition of definitely the 1951 convention with its 1967 protocol. Then the definition of the Organization of the African Unity, OAU 1969, and the Cartagena Declaration 1984 of Central and South America, as well as the Asian African Legal Consultative Committee definition available in the Bangkok Principles on the Status and Treatment of Refugees 1966. The 1951 Convention, if we go back to 1951 Convention once again, it claims to be based on the principles of humanitarianism. It has rightly, therefore, been recognized as an important document of both human rights law and international humanitarian law. However, remaining circumscribed by the principles of state sovereignty and principle of non-interference, that no state can interfere into another state's internal affairs. These two characteristic features of, they were part of the, international relations that developed, through the Treaty of Westphalia and other developments, Treaty of Westphalia of 1648. So this 1951 convention, it being a product of the European crisis in the immediate post-war era, it has not always been able, as I would say, to live up to the humanitarian expectations. Because I just mentioned that it claims to be based on the principle of humanitarianism. Over and above, the Cold War origins and Eurocentric bias of the 1951 convention cannot be denied at all. In fact, in addition to their desire for the refugee definition to serve strategic political objectives, the majority of states that drafted the convention sought to create a rights regime conducive to the redistribution of the post-war refugee burden from the European shoulders. So this was important. This was one of the major objectives which we tend to overlook many a time. In other words, the erstwhile European colonial rulers, they decided to define a refugee according to their convenience, and that definition was eventually thrust upon the rest of the world, particularly after 1967, including their former colonies in Asia and Africa. And most of the uh, decisions, policy and opinion makers of the new post-colonial societies, post-colonial states have not yet been able, as we know, to decolonize their minds, decolonize their thinking process, and therefore they are bound to stick to the 1951 Refugee Convention that claims to be universal in nature. Therefore, we can say refugee law, for all practical purposes, is too embedded in domestic immigration laws, as we can see even in India, Foreigners Act and other things, and institutions of the erstwhile European colonizers and colonies. Meanwhile, most of the states, both in the global north and global south, continue to view and treat the refugees, asylum seekers, and stateless population, migrants, mainly from their geopolitical concerns and cartographic anxieties. Therefore, it is not surprising, as I said, that most of these people of these categories, we can categorize more: refugees, stateless people, migrants, asylum seekers. Most of these people surviving in precarity and unfreedom, and they, as I would argue, remain pawns in the global diplomatic chessboard. Having said that, let us now come back to South Asia. In this context, in this overall context, as I said, if we try to revisit very briefly the process of decolonization of the countries in South Asia, and also scrutinizing the British colonial rulers' hurriedly redrawn boundaries of the late colonial period, we can find, doing this exercise, we shall try to address ways in which the process of mapping the would-be post-colonial states, it has been problematic. Using a couple of examples from South Asia, I would like to show how subsequent policies of the post-colonial states in South Asia, including the new citizenship acts or amendments to the existing citizenship laws or acts, impacted migration in the region and led to the generation of new refugees, rendering more and more human beings stateless. In South Asia and elsewhere, we have to also remember that later on we have a new category of internally displaced persons. It may be that displacement due to conflict. It may be a conflict-induced displacement. It may be a development-induced displacement. It may be a natural disaster-induced displacement, like the climate refugees. So there are new categories. So these internally displaced persons, which were, these IDPs, they were defined later in the 1990s in another context. So today's IDPs, the people who could not cross the international border, and therefore they are in their own homeland, in their own country, they quite often turn into refugees. And sometimes they also become stateless without even the right to have rights. Now, my examples from South Asia will represent major trends addressing how the inhabitants of South Asia were gradually and systematically dispossessed of their basic rights as human beings and expelled to a world of unfreedom and precarity with the assistance of discourses from the modern nation states and parameters of modern citizenship concepts and laws derived from the global north. Finally, I shall tell you to what extent these primary Eurocentric universal, so-called universal refugee and migration policies would be suitable enough to deal with the population flows in South and Southeast Asia. The regions, particularly South Asia, it has produced and also has become refuge for millions of displaced people since the decolonization of this region and the simultaneous partition of the Indian subcontinents. Now, if we look at the Indian borderlands, the Indian borderlands serve as a home to populations whose movements influence and are also heavily influenced by the livelihoods, commerce, and border management regimes working in these areas. These multiple systems create opportunities for and obstacles to movements within borderlands and across newly created borders of the concerned countries. The mobility of capital and technology has, been deregulated during the last 40 or so years. But migration, whether voluntary in the form of economic migration or involuntary or forced migration, has increasingly been shaped by the national, regional, and global regulatory norms and mechanisms on the one hand, and on the other, by national and or regional security enhancing institutions and mechanisms. So growing neoliberalization of economies, it has again led to the increasing disposability of refugees and migrants. The lack of state empathy is growing, lack of state empathy and support on the one hand, and widespread xenophobia on the national scales. Both these have led to more ad hoc policies vis-a-vis the refugees and migrants in the recent times. These solutions, the solutions generated by the nation states and also by regional organizations like European Union and also the so-called international organizations, these solutions tend to prioritize accumulation of capital by disposition over the everyday life of refugees and migrants, creating more precarity and unfreedom for the dispossessed people. The refugees and migrants, in other words, are rendered disposable populations and are forced to survive through informal structures within neoliberal economies, which we cannot forget. The Westphalian template of international, in reality, I would argue, interstate relations, which gives each state sovereignty over its territory. That means supreme control over its own territory, population, resources, etc., is ill-equipped to deal with tensions between more open economies and ever-increasing human mobility. As the post-colonial societies of the global south largely inherited colonially demarcated and sometimes arbitrarily partitioned territories, as in South Asia, they also legitimized and reproduced the colonial boundaries. This quite often led to the fragmentation of earlier economic and cultural networks that we had in different ethnic communities. Exclusionary impulses gained more strength in this frame of state-nation, underscored as nation-state. Spatially bounded parameters of belonging, based on the ideas of nation-state, borrowed from the global north, have only excluded more people from the nation in South Asia, dooming them to a bare life of unfreedom and precarity. Subjugating colonialism has given way, therefore, to post-colonial nations they are also passionate about securing territorial integrity of the new states, yet unconcerned for the people who inhabit those territories for ages. The birth of the modern territorial nation state, perhaps we can say, necessitated the mapping of nations and demarcation of borders and boundaries of Europe. And these new ideas soon spread to the one-time European colonies. In fact, the European colonizers has already started to demarcate borders in their respective colonies to distinguish their own zones of control and influence. In certain cases, when the colonial rulers could not control the frontier areas, therefore we can see that India, we had Northeastern Frontier Agency, or what is now in Pakistan. Now NEFA, Northeastern Frontier Agency, is known as Arunachal Pradesh. In Pakistan, bordering Afghanistan, there was this Northwest Frontier Province, or NWFP, which is now known as Khyber Pakhtunkhwa. And even in Burma, or today's Myanmar, there were these frontier regions during the British colonial periods. So the colonial periods, when colonial rulers when they could not, control these frontier areas, they granted some degree of autonomy to deter outside powers and buy peace in the region by, entering into some kind of agreement with the local indigenous population. Accordingly, the British colonial governance in the Indian subcontinent was primarily based on a strategic appreciation that allowed for a lighter colonial administrative footprint and greater autonomy for indigenous communities. This period began the demarcation between inside and outside of a colonial territory. It was there in the European nation states. Now it came to the colonies. So as the British colonial rulers hastily left their colonies, the colonial boundaries and frontiers became de facto boundaries of the post-colonial states, following the principle of uti possidetis juris, a specific legal term, legal mechanism in international law that serves to legitimize the colonial borders in post-colonial times. Now, territoriality is the ability to enforce a writ over a particular geographical space or spaces. And it plays a key role in this conception of modern statehood. The state boundaries became testing grounds, therefore, for sovereign rule, especially in the newly demarcated boundaries of the global south. In fact, the imperial histories have demonstrated the complex nature of relationships between colonial sovereignty and border making. Drawing borders also posed cartographical and territorial challenges in South Asia, particularly when freshly demarcated lines on maps only nebulously followed geographical and sometimes ethnic contours. But it also raised issues concerning relations between the new states and their citizens as subject of colonies, now constitutionally turned into citizens of new post-colonial nations. Citizenship, therefore, remains a contentious issue, even after 7 decades of decolonization in this region. This seems true if we scrutinize the newly enacted citizenship laws, as in Burma, now Myanmar, or in Bhutan, which was not a colony, but even then in the early and late 1980s, or the existing acts that were amended, as in India, in 2019. All these efforts are part of nation-building process that involves the inclusion of certain communities within the fold of a post-colonial state and the simultaneous exclusion of the remaining communities from the same political space. In fact, when empires end, they often leave behind colonial borders and the subsequent complicated nature of nation building with its social and political production and reproduction of borders and nationalized spaces. A close analysis of South Asia in this regard uncovers complicated stories of post-colonial nation building and boundary making that involve reconciling the inherited complexities of the colonial borders while coping with the exigencies of newly demarcated boundaries. The nation building in this region has been intended to homogenize a plural society consisting of different religious and ethnic communities and historically sharing the same territorial space. It thus, we can say, homogenizes a heterogeneous space into territories to be controlled by a monopolistic state power, with territorialization of the post-colonial space a major precondition for the emergence of politics in the modern sense. For the architects of nation building in South Asia, it was nearly impossible to identify any single logic of nation building in the region. Therefore, nation building and boundary making highlighted far more emotive, troubled processes through which colonies eventually became post-colonial states with intent to become nation states in the European style, while still opposing the European colonizers. Borrowing from the decolonial thinkers, therefore, I would argue that the global South is a product of the empire, conceived to express all forms of subordination brought about by the capitalist world system of the global North. Once the new borders were drawn or redrawn in this newly decolonized South Asia we are talking about, major distinctions needed to be made at the borders between citizens and foreigners, insiders and outsiders, and between those who would be allowed entry and those who would not be. Therefore, the new state nations, my preferred name for them instead of nation states, started to close their borders. Within a decade, the new borders became inseparable from the concept of passport, except in case of the borders between India and Bhutan and India and Nepal as a result of the contested bilateral treaties between these concerned states signed in 1949 and 1950 respectively. Meanwhile, as we know, that the communal riots following the partition caused the deaths of more than 2 million innocent men, women, and children. One of the largest mass migrations in the 20th century occurred between 1946 and 1957, when at least 15 million people were forced to flee from or in fear of bloody communal riots. So that fear of persecution, it was there, and seek refuge across the newly demarcated international boundaries. There was no 1951 convention or UNHCR to fall back upon during one of these largest mass migrations of the people in the 20th century. And as we can see that how these people could be, accommodated, could be rehabilitated, resettled in these new two states of India and Pakistan. Regarding India, Professor Ranabi Shomadar, who is also in this, discussion today, he's also here. He edited a book, The Refugees and the State, long back, and it has dealt with this question that how the societies in this region, they accommodated when there was hardly any institutional practices, so to say, both national as well as regional or international. Now, as partition continues to influence how the peoples and states of post-colonial South Asia envisage their past, present, and future, fresh exodus of refugees to India occurred again on the eve and during the 1971 liberation war of Bangladesh, which was then East Pakistan. Therefore, if we take examples from South Asia, I will take two, like the Bhutanese Lotsampa of Nepali origin and Myanmar's, or earlier Burma's, Rohingya. We can see that we can also try to explain how the situation continued to be complex, and even after the birth of Bangladesh, when mapping the new nations had apparently concluded. I would be very brief now. You can, read more about these developments. I'm not going into the details, but very briefly, I will just go through it. First, the example of the Lotsampa. The Himalayan kingdom of Bhutan was never colonized, as I say, but it had a close brush with the British colonial powers when it signed the Treaty of Punakha in 1910. This treaty ensured that the British Indian administration would not interfere in Bhutan's internal affairs as long as Bhutan was willing to accept advice from the colonial powers, British colonial powers, regarding its external relations. In the late 19th century, the Lotsampa, the people of Nepali origin, primarily of Hindu background, settled in southern Bhutan, a previously underdeveloped and mostly undeveloped region of the Himalayan kingdom. Now, by the late 1970s, the dominant Drukpa community of Bhutan, who mainly follow the Buddhist ideals, became apprehensive about the influence this growing number of Lotsampa had on Bhutan's cultural identity. Therefore, the Lotsampa were soon identified as illegal immigrants, quote unquote, and apparent threats to Bhutan's survival as a distinct political and cultural entity. And this we'll find everywhere, not only in South Asia, but all over the world. Therefore, the government's mistrust of Lotsampa minorities intensified in the late 1970s and the early 1980s, and therefore it adopted a policy of national cultural orientation. In 1977 and 1985, it passed two citizenship acts in Bhutan that drastically altered citizenship requirements in the country. And having already viewed, the Lotsampa as illegal immigrants, the Bhutan refused to recognize the citizenship identity cards already issued after the last census in the country. Later, a decree from the King of Bhutan in January 1989 introduced the Driglam Namza, the traditional Drukpa code of values, etiquette, and dress, as the cornerstone of its Bhutanization policy. In the next month, in February 1989, the Nepali language spoken by the Lotsampa was also excluded from the school curriculum. Subsequently, through violent repression, forcible eviction, formal pressure, the Bhutan government compelled more than 120,000 Lotsampa to leave the country in and around 1990. They entered India through Phuntsheling Joygaon international border between Bhutan and India, which is an open border, to subsequently reach Jhapa and Morang districts in eastern Nepal through Panitanki Kakurbhita border region between India and Nepal, another open border, and seek temporary shelter in the refugee camps there. The government of Bhutan continued to view these Lotsampa refugees from the perspective of terrorism and criminality, and therefore argued that the problem of the, I quote, the problem of the people in the refugee camps in eastern Nepal is not a typical refugee situation, but one of highly complex nature with its genesis in illegal immigration. That means these Lotsampa came to Bhutan illegally. They were illegal immigrants only. And later now they try to claim that they are refugees. In 2008, following several failed negotiations with the government of Bhutan regarding repatriation and following the depletion of international aid for these refugees, the UNHCR decided to end this protracted refugee situation by resettling the Bhutanese refugees registered with this International Refugee Agency in the United States and other countries, including Australia, Canada, some Scandinavian countries, Netherlands, New Zealand, etc. Although many refugee families, they in the process got divided through this, artificial process of resettlement. Let us now have a very quick look of the rejected Rohingya. The Rohingya described as one of the most severely persecuted minorities in the contemporary world were once residents of Arakan state, which is now the Rakhine state in Burma, which is now Myanmar. They were excluded from Burma in 1982 when the nation's military junta enacted a new repressive citizenship law. It eventually rendered the Rohingya stateless without any citizenship of any country whatsoever, primarily on the basis of their religious and ethnic identity. And, in 1991 and 1992, 20 years back, about 250,000 Rohingya first fled an intensified post-election clampdown in the Rakhine state, marking the first exodus of Rohingya from Myanmar. My colleagues, Professor Samadar and Sucharita Sengupta, they are there. They have worked extensively on this issue. I'm not going into the detail. The subsequent large-scale persecution of the Rohingya led to their further exodus, primarily into neighboring Bangladesh, but also in smaller groups to Malaysia and Thailand. After the 25th August 2017, which was the largest massacre, the world was shocked by the images of hundreds and thousands of innocent Rohingya men, women, and children fleeing mass atrocities, which was later, termed as genocide. The 2018 report of a fact-finding mission also mentioned about that. We are not going into that. And earlier also, before the massacre in August, there were other atrocities. But in any case, with the August 2017 massacre, escalation of violence that created a humanitarian disaster. I'm underlying this word, humanitarian disaster, that forced over at least 730,000 Rohingya to flee their native land and seek refuge in makeshift and already overpopulated refugee camps near Cox's Bazar, Bangladesh, where the concentration of Rohingya refugees is one of the densest in the world. And as we had witnessed a military coup d'etat in Myanmar in February 2021, we can say that it is unlikely that these Rohingya refugees and stateless people, they would be able to return to Myanmar in the near future. As their expectations of being recognized by, as citizens with due rights and entitlements fade away, their prolonged situation of precarity and unfreedom, it is likely to create an intractable Palestine-style scenario in South Asia. I'm borrowing this term from my friend, journalist Martin Lindner, who has used this term last year in one of his articles, with the Rohingya as the new Palestinians of Asia. And we are not going into that. There are, some judicial pronouncements about the Rohingya, some of them in favor of the Rohingya refugees in India, some of them against it. For instance, the Supreme Court, the cases are pending, Supreme Court of India, but in Manipur High Court, there was a recent judgment which once again mentioned about Article 21 of the Constitution of India, and therefore, linking it with the principle of non-refoulement in the 1951 convention. But let us now move beyond that. And let us now come to, section which would deal about the legal geographies. We are trying to, move beyond this kind of perspective. Now, we can say that migration seems to be a legitimate area of sovereign regulation and governance for the post-colonial states, not only in South Asia, but elsewhere, where policies are calibrated according to the respective political goals and imperatives, and where sovereignty has precedence over the entry and residence of non-nationals. But international human rights and international humanitarian laws restricts a state's power to socially and economically exclude or deport a migrant or refugee who resides legally in its territory. International law also limits state sovereignty to regulate entry, for instance, through the principle of non-refoulement. But in South Asia and elsewhere, even in the global north, in the global south, there are new developments, on behalf of the states, that the states have the final say about the entry, residence, or deportation of a person arriving at the border or sneaking through it. Given the diverse origin and nature of migrant, refugee, and stateless peoples in different geographies and histories, probably we now need to look at these issues from a pluriversal perspective, not a universal perspective, that takes into account different legal geographies and different anthropologies of accommodation. Recent decolonial thinking, in contradistinction to most modernist and post-colonial ideas, has been more inspired by the indigenous movements in the global south, particularly in Latin America, by attempting to provide an alternative place and time from which to mobilize resistance to modernity and coloniality. These decolonial and pluriversal arguments have two basic premises. First, that dominant Western theory and practice depend on the particular ethical and political effects of a Euro-modern ontology. Second, that the Western ontology's claim to universality is also false. Now, post-coloniality may be regarded, why decoloniality? Post-coloniality may be regarded as a condition, a certain human existential situation, which we have often no power of choosing. It's given. That post-colonial situation, that condition is given. On the other hand, decoloniality is an option, consciously chosen as a political, ethical, and epistemical positionality. And also, we can say, an entry point into agency. Therefore, the post-colonial condition is more of an objective given, a geopolitical and a geohistorical condition, situation of many people coming from the, which were earlier colonies, now post-colonial societies. While the decolonial stance is one step further, as it involves a conscious choice of how to interpret reality and how to act upon it. In fact, the critique of modernity in the global south has largely been influenced by, its subordination to and dependency on a Western dominated world, even after decolonization. I'm not going into that. But as the world witnesses massive numbers of people on the move, it is now difficult to distinguish, as we know, between refugees and asylum seekers and migrants, economic migrants and stateless people. And we know that the refugees and asylum seekers, at least theoretically on paper, they are normally protected by the international refugee law. But the economic migrants who usually do not enjoy at least that level of protection. So there is a distinction. And the earlier classifications of these different categories are now gradually becoming blurred all over the world, not here. And similarly, after 9/11, the increasing efforts to securitize migration are pushing humanitarian concerns to the back burner. And this is evident from the recent situations within the European Union and from the approaches of bigger and smaller states elsewhere, in different parts of the world, who are beset with the populist ideas of ultranationalism, xenophobia, and therefore intolerant policies vis-a-vis refugees, asylum seekers, stateless people, and migrants. The South Asian countries, which are already obsessed with their newly acquired sovereignty and distraught by the nuanced impact of partition, have started tweaking, therefore, their citizenship laws in a larger context of populist politics, thereby exacerbating the ethnic fissures and eventually generating more refugees and stateless people. In this scenario, the so-called universal principles and laws probably fail to address the pluralities and complexities of the post-colonial world, including South Asia, thus creating more ethnic fault lines and widening also the existing ones. I thus maintain, in conclusion, that pluriversal arguments grounded in the anthropologies of accommodation offer critics to the universal ideas and legal positions emanating mainly from Europe and the Euro-American world. The pluriversal approaches claim to recognize and appreciate other cultures and other legal instruments emanating from other knowledges, other histories, and other experiences. The truly international, if we intend to make it international legal framework, cannot and should not be trapped within the Euro-American framework. I also argue that while creating emancipatory international and universal framework, we should consider the geographies of reason and law. As I said, therefore, that a decolonial approach to international refugee law would involve interrogating colonial logics, investigating the interconnectedness of historical configurations that continue to shape our present, and examining global power structures, not only in terms of geography or capital, but also in terms of epistemology. We may first consider the difficult position that international refugee law occupies as a field of legal practice and as a discipline of study. The existing refugee laws tend to underscore the notions of violence experienced, for instance, by the refugees, which seems to entrench the problematic idea that their legal claims reflect an exceptional and generally individualized forms of violence. And the systematic violence is bound by, the political boundaries or political borders. Second, it also appears to highlight the recent social imaginings of the refugee in Europe and the global north as a racialized criminal subject in need of humanitarian intervention. This kind of characterization of refugees legitimizes logics of state security and, on the other, stabilizes the state-building discourses of human rights. The state-building discourses of human rights also underscore how receiving states produce the systemic marginality of refugees. I'll here bring in very briefly Hilary Charlesworth, who 20 years back quite interestingly identified international law as a discipline of crisis. I quote, discipline of crisis, that seems to emphasize the most extreme articulations of violence, human suffering, and environmental degradation, appears to allow for what may seem a robust justification for the presence of international law to intervene in situations, the magnitude of which is so great and the victims of which enjoy such empathy that inaction invokes a sense of moral apathy. But the language of crisis, as I am saying, can obscure the systems and structures that undergird or support violence and suffering, focusing perhaps too much and too exclusively on the extremes, on the spectacles, rather than the everyday suffering that refugees experiences and the migrants go through during their journeys and in their reception in the host countries. In such circumstances, the international refugee law framework, primarily, in my understanding, authorizes action with the moral force of the reasoning of last resort, evoking a duty to mitigate these extreme forms of suffering. As we look at very briefly the recent New York Declaration, as I said, it raised, of course, expectations, a lot of expectations for better governance of international human migration by committing itself to securing the rights and protection of refugees and migrants in the context of human rights discourse and working toward sustainable development, which is the key word nowadays. But even this laudable initiative seems to have been triggered specifically, once again, as I said, by the reaction to the Europe's 2015 crisis, again another crisis, and the disconcerting images that circulated as migrants and refugees from different parts of the world crossed the Mediterranean to reach the European shores, with many perishing in the sea. And we ignore that how many Rohingya are in the Bay of Bengal region. Similarly, how many refugees and or migrants, they also perished in the sea in the recent times. And we tend to forget the Vietnamese boat people. Anyway, like all other previous attempts at the international level to formulate rules and norms for the governance of the people on the move, this effort, this recent initiative, also turned out to be predominantly influenced by the developments once again in the global north. Under such circumstances, the 1951 convention tends to occupy, even now, we must agree, the central gravitational force in teaching about refugee law. As we are teachers, we very briefly we can look at the teaching of law, refugee law, and refugee law syllabus. A typical refugee law syllabus commences with a discussion of how the Refugee Convention frames and defines the refugee, and it then examines the case law on refugee status determination and perhaps on other regulatory frameworks like the reception conditions, human rights to freedom from torture, etc., etc. In other words, the way we typically teach international refugee law in most cases is to focus on what makes a good claim as reflected in the jurisprudence of a particular jurisdiction or with a view towards regional or international trends or standards. In a purely legal sense, this is simply the way law works. Protection is defined here around certain rule-based parameters. However, as I see it, in a wider sense of understanding violence, subjectivity, and broader relations of power, this approach to teaching of international law misses the forest through the trees. And before I conclude, finally, let me also tell you that when I refer to violence, I do not mean persecution, but rather broader forms of physical and epistemic harm that are inflicted on individuals and different groups. My focus is on harms attributed, by the state and in different ways, and this is more important. And the core of teaching of refugee law, as I said, that it is only on the determination aspect and what kind of claims the refugees can have. The persecution does not enjoy. They are talking about fear of persecution and other things. This persecution does not enjoy a precise definition under the 1951 Refugee Convention and can be considered to lack determinacy for this reason. Therefore, the states, what we see, tend to interpret, the bar on the level of violence or social exclusion to be quite high. Other forms of violence which do not meet the threshold that states understand as constitutive of persecution are not considered when refugee status is being determined. We need to remember that if we fail to discuss the treatment of refugees in receiving states as well, including the interplay between criminal law, immigration law, and public law, domestic law, in the context of broader social well-being of refugees, we will fail to see the ways in which their claims are instrumentalized and their stories are understood legally and socially, both. This is a question that even the most nuanced and hopeful readings of the protection offered by the 1951 Refugee Convention may not help answer. In addition, if we fail to teach about the context of the masses of people who might cross borders if they gain the opportunity, security, or energy to do so, including the global and historical circumstances, which may have catalyzed such need for movement, we risk failing to understand the core of the violence that the people on the move face and in which we as a global community are complicit. Second, we need to present refugee law and immigration law more generally within the broader context of global power relations in order to properly identify its limits, its inadequacies. If we are really concerned with the transformative potential that decolonial and critical thinking promises. We should do this in a way that takes historical developments into account, the social context, including the racialized colonial relations, and we should perhaps be able to confront the use of nationality as a proxy. I underscore this, as a proxy for racial and other types of difference in the regulation of borders. International refugee law tends to portray the persecution of refugees mainly as a function of European circumstances, as I said, rather than embedded with global historical structures, as international refugee law, perhaps in the post-war era, was never meant to address the root causes of global material inequality, war, and devastation represented by those who cross borders in search of peace, health, and safety. Even, as I said, it was not only the 1951 convention, but if we look at the recent New York declaration and the two global compacts, they have also failed in a similar manner. I think I will stop here. I've already crossed, time limit. I apologize for that. And now it is open for discussion.
Can I ask a question? It was a nice session.
Thank you, Shonali. Yes, go ahead.
Uh, See, this whole notion of developed world, developing world, global south, global north, these all are being created by the European nations, those who colonized the world. They created this. We used to be called golden sparrow, and we have enough resources in our country. And when Britisher left India, we were like left with nothing. The resources, they took everything away from us. And first they created first with their internal conflicts or whatever their problems. First world war occurred, and then second world war took place after that. So first they are creating problems, and then they are giving, then they themselves are finding out the solution in terms of conventions, 51 conventions, 67 protocols. And even those are not up to mark, because they have not touched many aspects like the environmental aspects, climate, refugees aspects, and then also not been following by many countries. But though India did not sign it, but still India is accepting many people on the moral grounds from outside the world, and it is giving refuge to so many people. So I'm saying, when these conventions are not being followed, then why we have to discuss them, and how it is going to take us further, in which direction it will take us.
I think Shonali, I have got your point, and also Manjesh has a similar question in the chat box.
Okay.
So first of all, let me tell you that whenever we look at the South Asian situation, as I explained, as you have also rightly mentioned about the developments in South Asia in the post-colonial period, we know all the realities. And we have to also understand that we discussed 1951 convention, and we also try to analyze that why we do not ratify the 1951 convention. Pakistan is not ratifying because India has not ratified, so on and so forth. So this debate continues without going into, as I said, the epistemic debate, the epistemic discussion. These are only, the superficial discussion. So most of the scholars, they have always been discussing this, that yes, the 1951 convention, as I said, it set a standard at the international level, at the global level. At least it claimed to be setting a standard at the international level. It was expanded to the rest of the world in 1967, as I mentioned in my lecture. And it is now considered to be a universal approach. Now, the point is that in South Asia, in Africa, as I said, there is this OAU convention. In South America, there is this Cartagena Declaration of 1984. So at least there were some regional initiatives to, take into account the regional specificities, apart from the universal logic, apart from the universal morality, universal ethics. So in case of South Asia, in case of Southeast Asia, in spite of the Bangkok Principles I mentioned in 1966, in South and Southeast Asia, we do not have such regional conventions to take into account, to consider the regional specificities. And therefore, we have to take some standard into account. And you are right, Shonali, and all of us know that South Asia has been, generating, the South Asian post-colonial states has been generating millions of refugees, as I mentioned, but also at the same time, also the largest recipients of refugees. So they try to, accommodate these refugees through other means, as I say, as Professor Shomaddar's book mentions quite clearly, that this was through, the social process, the social acceptability. The people on the other side of the border, they belong to the same ethnic stock. So the Punjabis, coming, the Hindu and Sikh Punjabis coming from Pakistan, the newly created Pakistan, were accommodated in this part of Punjab, in eastern Punjab. Similarly, it happened so far as the Bengalis were concerned. And even, the people going to the other side, the Punjabis going to West Pakistan and the Bengalis going to East Pakistan. So it was mainly a social process, a social accommodation. And that is why I mentioned about anthropologies of accommodation. It has nothing to do with the institutional practices. Even the newly created post-colonial states, they had very little resources to accommodate these refugees, to resettle them, to rehabilitate them. There were initiatives in bits and pieces by the federal government, by the provincial governments, but that was too little. So it was mainly the social practices, the anthropologies of accommodation that helped the process. On the other hand, there should be some standard. There should be, because law is for all. Law cannot be applicable to one. Law cannot be for a single person. Law is applicable, be it domestic law, be it international law. It should be applicable to law. That is called rule of law. So everybody is equal before law. That is what we say. And therefore, this 1951 convention, which defined refugee, this is important because there was no, such definition in South Asia. And if you look at the South Asian countries, as you raise this question, you won't find any model national law. I'm also addressing Gurmit's question. That Gurmit asked that, do you think that a model national law can fill the gaps? Yes, probably to a great extent. But as I see it, in 75 years, we'll be celebrating our independence of decolonization 75 years next year. So you'll see that in these 75 years, although we, accommodated so many refugees from Bangladesh, from Pakistan, from Sri Lanka, from Tibet or part of China, and other countries from Myanmar, from Afghanistan, and other countries as well. We did not bother, and we are always, the Indian government has been, more comfortable without any model law. And they would argue that, yes, what's wrong with us? We accommodated all these refugees. We gave shelter, provided shelter to them, irrespective of UNHCR. UNHCR was not allowed in most of the cases, even when UNHCR was created and they were interested to work on Sri Lankan refugees or Chakma refugees from Bangladesh, they were not allowed to work with them. So even with that situation, the government of India would argue, and it has a logic, of course, that we accommodated so many refugees. So why do we need a model national law? And why do we need to ratify the 1951 convention? Is it not enough that we accommodated all these people with a human face? So what's so big deal about an international refugee law and ratifying that text? Why is it so important? And when it is more Eurocentric, and it was in the context of the Second World War, it was in the context of West European situation, in that kind of refugee situation at that point of time. There is a question by Mohana that if I can explain the question of refugeehood in respect to the tribal groups. You see that there is no special, kind of logic about the tribal groups or indigenous communities. Because when we look at the international refugee law definition, it says that, all kinds of people who are, in some kind of fear of persecution, of being persecuted, they come under this definition of refugee. So even the indigenous communities, if they are identified, if they are targeted on the basis of their indigenous identity, they belong to the same category. But in case of, if we have no scope to discuss the IDPs, the internally displaced persons in this lecture, there may be a different discussion and somebody would definitely discuss about it. So in case of the IDPs who are, at the mercy of their, own government being displaced, and as I said that they can be displaced due to conflict, they can be displaced due to development programs, they can be displaced due to the natural disasters, the climate change, everything. So in that case, if it is a development-induced displacement, it is the government of, their own country, which is, taking certain steps, which they think that it is development, it is better for the country, it is better for our population, our inhabitants, which may not be development, which may not be considered to be development for the indigenous population. And Walter Fernandez and his colleagues, they made a very elaborate study on the development and displacement in India between 1950 and 2000. And there in that study, which is an extensive study, and so far there is no, state-sponsored, government-sponsored study in India. about the development-induced displacement in India. Of course, the IDP is not the refugees so far. Therefore, there is no, substantial data with us to challenge Walter Fernandez and his colleagues, formulation, their argument. And there, Fernandez, Walter, and his colleagues, they argue that at least more than 50% of the displaced persons displaced due to development projects, they have been indigenous people. And if you look at the percentage of population in India about the indigenous, the tribal population, it is about 8%, 7.58, around that. Therefore, about 7.5 or 8% of the Indian population. Out of that, I mean, when we look at the displaced population, due to development projects, more than 50% of the displaced persons, they belong to this category. So this is the problem with the IDPs. But in case of the refugee definition per se, there is no problem, because even the indigenous people, they would belong to, they can also be identified as refugees, and they can also be considered as some people who is in fear of being persecuted. Aparna is asking that, are there South Asia specific regional agreements on refugees? Not so far. There have been, civil society initiatives, but those civil society initiatives, it has not been, recognized by the states concerned. And as I say, that whenever we talk about international refugee law, this is the problem. And now we are moving towards, I would argue, from the era of international relations that, came into being from the Treaty of Westphalia, when the territorial states, the sovereign states, they were, emerged, and they became the main actors in the so-called international relations. Now you have, you are having neoliberal economies with, capital, corporate capital playing a different kind of role. So in this situation, when the world is being globalized and the mobility of capital, mobility of technology is much easier, but mobility of people, it is not at all. So I say that there are simultaneous processes of deterritorialization and reterritorialization. Deterritorialization in the sense that when capital is moving from one country to another and technology is following capital, it has no barrier as such, because the states, even with their supreme control over the territory, they are allowing the parliaments, the courts, the judiciaries, the executives, all of them are allowing. And even in this age of corporate capital, the media are also being controlled by the corporate capital. So there is some kind of a consensus among the elite that neoliberal economy is the order of the day. But now, on the other hand, so this is deterritorialization of space. On the other hand, you have this, more and more populism of different kinds, xenophobia. You have, fear about the outsiders, about, the strangers. And therefore, there is also a process of reterritorialization, not only in the global south. The global south countries, the South Asian countries, they have sovereignty in recent times. They have this concept of territoriality. They have to, securitize territory. That is a recent phenomenon of the last 70, 80 years. But if you look at the global north, you look at the European Union is also doing the same thing. So within the European Union, the mobility has become easier. But on the other hand, around the European Union's border, you are trying to, fortify Europe from the rest of the world. This is becoming Fortress Europe. And therefore, the outsiders, the people from the global south, they may be refugees, they may be migrants. So they are not being allowed. And you will see that European Union paid how much money, how many euros, millions of euros to Turkey. Why? Now they are not on the same page with Turkey on many issues, but they have paid so much money to Turkey so that the Syrian refugees and other refugees crossing the Mediterranean or coming through, the Turkish-Syrian border, they don't enter the European Union countries. Therefore, it is a new kind of policy. And there, as I mentioned, there is no scope of discussion here that there has been initiatives to externalize, this refugee situation in order to, avoid this kind of the principle of non-refoulement, that somebody is at your doorstep seeking shelter, seeking refuge. You cannot deny him. You cannot deny her. So this principle, which was in jus cogens. Jus cogens means it is a technical term of international law. It is a customary law. Customary law is those laws which were in existence for a long time, but it was not codified. It was not in written form. Many such laws they were in the form of customary law, in the form of customs, practices. Okay, so when they were codified, it became a law, so to say, some kind of a positive law. But again, all around we have to remember that international law is a soft law. It is a soft law because in case of national laws, there are, mechanisms. There is government, its executive, and also its judiciary to look after whether the laws are being followed, whether the citizens are following or the institutions are following the laws. There are so many institutions to look after that. Part of the executive, part of the judiciary. And then there is the watchdog of media. But in case of international law, there may be criticisms. But who is going to execute these laws? When these international laws, when these international norms, these international standards, they become part of your national laws, our national laws, then only they can be implemented. So how it happens? Either the governments, the states concerned, they have to legislate their own laws in accordance with this international refugee law and along with the international human rights law and international humanitarian law. Or what can be done? Even the courts, the judges, the respective judges, the honorable judges of the Supreme Court or High Court, whenever they deliver the judgments, if you look at the case laws, in social sciences, we care a fig about the case laws. It is only the domain of the lawyers, legal practitioners. But even in social sciences, we need to go through the case laws sometimes. We only mention one or two case laws. These are mentioned in the textbooks. But if we go through the judgments delivered by the judges of the Supreme Courts or the High Courts of different countries, not only in India, we'll notice that these judges, in many a case, they cite many instances or precedents in other countries as well. Not only, when Indian Supreme Court judge is delivering a judgment, she or he is not only consulting some precedent from the Indian situation, not only from South Asia, but also from other parts of the world. It may be also from Africa. It may be from South America. It may be from Europe or, North America. So this kind of precedent, when it becomes part of the judgment, then it becomes a precedent in the Indian context or the South Asian context. So this is important. And another question is from Vishwajit Mohanty, that if law is universal, then how pluriversality perspective be accommodated within universality of rule of law? You see, Vishwajit, the point is, law is universal in the sense that when the law will be framed, being a lawyer, you know better than me with your legal training, that when the law will be framed, it will be applicable to one and all. But when I talk about pluriversality, that is for framing the law, taking the, necessary kind of inputs from different cultures, different histories, and different geographies, and different anthropologies. But when we talk about the international refugee law, mainly the 1951 convention, as I mentioned, that it was mainly in the context of the Second World War and in the context of Western Europe. So it did not take into account or could not take into account, both probably did not, due to the colonial mindset, that the other geographies, the other histories, the other cultures, the other anthropologies, and other legal systems, they were completely ignored. They were completely excluded. And therefore, as I said, silenced. So pluriversal is for framing the law, pluriversal approach. But once the law is made, is framed from a pluriversal perspective, definitely it gets an international character. It becomes more and more universal, and people in different countries, the states in different countries, they would also be happy. They would not resist this so-called international law. How global is the Global Compact? And, the Calcutta Research Group, it had published, it prepared a Kolkata Declaration in 2018 during its annual winter workshop. So how global are the Global Compacts? They're not global. Once again, again originated from the 2015 Euro-Mediterranean crisis. So where is the pluriversal approach? That is my point. The role and contribution of refugees, stateless persons, asylum seekers to the economy, and yes, they definitely have their contributions, but it is the perspective of the states. And if you distinguish, as I said, that if you look at the critical race theory, here I mean, as I mentioned, while I'm talking about the racial perspective, I'm not talking about race per se as it used to be viewed earlier. It is also in the national context, in a broader context. Therefore, if we look at it from the critical race theory, we'll see that nowadays, I mean, there are these discrimination when we apply the international refugee law and when we, accommodate migrants. And now there are, because all these issues are related to, we don't have much time, but you know that all these issues are related to the citizenship question, land question, economic question. So definitely they are contributing to the neoliberal economy. And as I said very briefly, that it is accumulation by dispossession. So whenever people are being displaced, they are being, somehow they are forced to quit from a particular region. Their land doesn't remain, vacuum, completely free. Some other people, for some other purpose, even the state, they try to occupy that land and, they try to use that. Shishir Tiwari has a question whether the principle of non-refoulement has acquired the status of jus cogens. Yes, it already had the status, that recognition in jus cogens or customary international law. But the point is that even being codified in the 1951 convention, the problem remains that if the countries do not really recognize the 1951 convention to that extent, I'm not going to purely legalistic, technocratic term that whether we have ratified or not. Even without ratifying, are we really honoring that principle? Many of the countries, even in the global north as well as in the global south, they are not honoring this principle. I think I will stop here. It's already past 8 o'clock Indian Standard Time. So once again I hand it over to Shatabdi.
Yes, thank you very much, sir, for the engrossing lecture. We request everyone to please, we don't have much time today, so we'll just leave the questions till wherever sir has discussed. Professor Ronabi Shomadar, do you have anything to discuss or ask, sir?
I don't have anything. My thanks to Sabyasachi. It was an excellent lecture. We all learned. And thanks to the participants. I thought the questions were very good. And they enriched the discussion. Thank you. And Shatabdi, Shamata, all of you, thanks very much for organizing.
Thank you, sir. Thank you, Professor Basuraj Chaudhury, again for the wonderful class. So,
thank you.
Thank you.
Yes, sir.
I thank all of my colleagues in CRG for organizing this. Thank you very much.